Hi, my name is Chris Ukins. I'm a professor at George Washington University Law School in Washington, D.C., and thank you for joining us for this session of Anti-Corruption Measures in Procurement, Public and Private Perspectives. This section is called Section 2A. It's a section on anti-corruption strategies that are used in procurement systems around the world. This is a course sponsored by the International Anti-Corruption Academy. Thank you again for joining us. Before we view these various anti-corruption strategies, it's worth all emphasizing a couple things. First of all, that the anti-corruption strategies in different systems around the world are very similar. They're very parallel to one another. That is probably due to the fact that the anti-corruption strategies are addressed to common pathologies. We talked in an earlier unit about the principal agent problem, because there are common pathologies or common problems in procurement systems as the procurement systems struggle with the problems presented by the agents, by the contracting officials, and by the contractors. Because the pathologies are common, so too are the solutions, the anti-corruption strategies, common. The second thing worth noting about these anti-corruption strategies that ring fences surround a procurement system is that they don't just deal with what we would consider traditional forms of corruption, things like bribery or gratuity. More broadly, they deal, yes, with criminal corruption, as we would understand it traditionally, but they also deal with more mundane issues of ensuring best value in procurement. They are, just as the bribery and gratuity rules are really fundamentally directed to ensuring that the contracting official makes the best value decision. These other tools that we'll be discussing, other tools that aren't part of the traditional panoply of anti-corruption devices, these other tools, these other anti-corruption strategies are also directed towards achieving best value. So we see a merger here between traditional anti-corruption strategies and what really are procurement strategies, strategies inside a procurement system to ensure best value. They all come together around this idea of ensuring best value in procurement. So a quick overview of these various anti-corruption strategies we'll be going through in more detail. Again, these strategies surround the procurement system, help ensure the integrity of the procurement system. The first is qualification, which is really the qualification of the contractor, making sure that the contractor is qualified, or as we call it in the United States, responsible to do the work. Debarment is an extension of qualification. As we'll see in a few minutes, debarment is an exclusion of contractors that shouldn't be found qualified. Next is criminal prosecution, addressing what we consider traditional forms of corruption, such as bribery or gratuities. Anti-fraud is an emerging and important area of anti-corruption. It's addressing deficient performance, and that's something that tends to get overlooked in anti-corruption strategies. We'll talk about oversight, different ways that oversight is exercised over procurement systems by investigators, for example, or legislatures. We'll talk about corporate compliance just very briefly, because in the next session, we'll be talking about compliance in much more detail. We'll talk about boards and the role that they play in ensuring integrity in procurement. And finally, we'll be talking about audits and how auditors can play a very important role in making sure that the system remains clean. So let's talk for a minute about contractor qualification. Contractor qualification really is at the heart of any modern debate or discussion of anti-corruption and procurement, because so many of the issues funnel into this question as to whether or not the contractor is qualified or responsible to perform a contract. For example, you're looking at the history of ethics and compliance. Has this contractor experienced corruption in the past? Has it engaged in corruption? If it is, then it probably isn't qualified to perform for the government. But this question of contractor qualification tends to get muddied with the question of past performance. Should we assess contractor qualification as part of a separate issue, or should we also consider past performance, or consider past conduct as part of a past performance assessment, perhaps scoring it? So these are difficult policy questions that have to get worked out. Should the qualification information be standardized so that it's easy to exchange information between governments, for example, and it's easy to track that information? Should it be more nuanced? Should there be narrative discussions of the qualification? Should the contracting official have to produce a record of why he or she finds the contractor qualified? Most simply, should the contractor qualification be assessed at the beginning of the process, as it often is in the European Union, or at the end of the process, as is done in the United States in the federal system? Should contractor qualification be periodic? Should, for example, a contractor be able to certify its qualification once a year, or should it do so on a contract-by-contract basis? And finally, on this issue of governments exchanging information, should a government work really hard? Should it strive to make the information on contractor qualification readily available on the internet so that other governments can take the benefit of that information as well? An anti-corruption strategy that's related to qualification is debarment. While qualification is typically done on a contract-by-contract basis by an individual contracting official, debarment is excluding a contractor from an entire procurement system or even several procurement systems for a period of years, let's say a period of 3 or 5 or 10, or perhaps years, or perhaps permanently. So debarment is a longer term exclusion rather than being excluded from a particular contract, which is again what a qualification is. Debarment is rapidly evolving worldwide. You see more and more procurement systems developing their own systems for debarment. And while it's an extension, it's commonly recognized as an extension of contractor qualification or contractor disqualification, as it were. But there's an open question about whether or not debarment should be used as a sanction for bad acts, or whether or not it really is a business decision. Is this really a business decision being made? Are we trying to sanction contractors that have done, for example, corruption, have engaged in corruption, or are we trying to exclude them because they pose reputational risk, or because the corruption indicates that in fact whatever they're doing for the government poses performance risk? Is this a sanctioning process, or is this a business decision? And then a related question is whether or not other jurisdictions should cross debar, whether or not a jurisdiction and an adjoining jurisdiction, or even a jurisdiction around the world, a nation around the world should say, oh look, there was a debarment in this other nation, therefore we're going to debar as well. Resolving that question about whether or not there would be debarment, whether or not that's an automatic cross debarment, or whether or not it's a debarment based on an investigation in, let's say, in the second nation based upon a debarment in the first nation. Whether or not there should be cross debarment, that's informed in part by how we approach debarment in general. If it is a sanction, if one nation is debarring a contractor because that contractor has engaged in bad conduct, it's less likely that another nation will want to rely upon or use that debarment. But if it really is a business decision, if the contractor is being excluded, for example, because the corruption indicates that it poses performance risk, the second nation may well want to rely on that debarment decision, may well want to cross the bar. So let's talk for a minute about criminal prosecution, which for many people is really the heart of anti-corruption in procurement. This would include, of course, bribery, which is a bribe is when a public official takes an item, a gift, for example, an inappropriate gift, in return for performing inappropriately, corruptly, a specific public act. That's bribery. Gratuity is related. A gratuity is when a gift is given to a public official in recognition of the public official status with a corrupt intent. So the idea is that a gratuity is a gift that can help encourage that public official to act on behalf of the gift giver in the future. A kickback typically involves commercial bribery. Typically it involves an arrangement between a prime and a subcontractor, for example. The subcontractor really isn't the most qualified subcontractor, isn't the best subcontractor in the marketplace, but wants to participate in procurement. The subcontractor may, in essence, give a commercial bribe to the prime contractor in exchange for an opportunity to share in the overall procurement, to be a subcontractor. That's a kickback. Another area of criminal prosecution and anti-corruption in procurement is on the question of conflict of interest. Now, personal conflict of interest, if for example, a contracting official gives a contract to his sister, that's a personal conflict of interest. More complicated are organizational conflicts of interest. And so, for example, an organizational conflict of interest in the U.S. government is not dealt with as a criminal matter, it's dealt with as a civil matter. An organizational conflict of interest is when a vendor or a firm, for example, may provide advice to the government on a future procurement in which that vendor itself may bid. That's an organizational conflict of interest. And that is typically dealt with as a civil matter, not as a criminal matter. Another issue that's related, though, is with conflicts of interest is revolving doors. So, for example, if an official leaves the government and goes to work for a contractor, that's referred to as a revolving door problem. And if the official, having gone to work for the contractor, gives that contractor a competitive advantage on the next procurement in front of the official's old agency, is that a criminal matter? That's a complicated issue that has to be dealt with under the laws of a specific country. What's worthwhile noting here is we should go back to the principal agent model that we talked about before. Remember, in the principal agent model, we have two tools, two basic methods to deal with conflicts of interest in officials. One is through monitoring, and another is through sanctioning. Criminal prosecution is really very clearly a sanction. And in some systems, we may discover that, in fact, the criminal prosecutions or the criminal penalties are not really there. The nations don't use them. It's not because those are more corrupt nations, but it may be because in those nations, because of the structure of the society or because advances in technology, whatever it is, that the society is better able to rely on monitoring rather than on sanctions in order to vitiate or eliminate the conflict of interest that the official might have. So that when the official is facing a procurement decision, instead of criminally sanctioning the official for engaging in a conflict of interest, we can try to resolve that problem through monitoring instead. You can see there the balance between monitoring and sanctioning in trying to resolve issues under the principal agent model. Another issue in anti-corruption procurement, and this is an issue that's too often overlooked in systems, is how do you deal with fraud in a procurement system and a fraudulent failure to perform? Many systems haven't really evolved answers to this question. It's oftentimes dealt with as a question of contract administration, and regular civil remedies are used, regular civil contractual remedies are used, when in fact there might be something more serious. This is a picture of a bridge that collapsed due to a design failure, and it collapsed at the Tacoma Narrows in Washington State in the United States in 1940. And it raises questions about whether or not there should have been a better design. The wind whipped this bridge back and forth until it ultimately collapsed. And the question is whether or not, was that a design failure? Was that just an act of God? Was that something that the contractor should have been able to deal with in building the bridge? So you see here a tension between contractual claims and fraud claims. To try to resolve that tension and try to move forward with anti-fraud, there's a few critical issues that have to be addressed. First of all, oftentimes the government relies on whistleblowers for information to explain where the defect actually came from. And then the question is, okay, how do we deal with the whistleblowers? Because the whistleblowers are going to be very exposed if they're disclosing fraud. Do we incentivize them by giving them, for example, a share of whatever the government recovers? Or do we try to protect them, legally protect them, say that, for example, they can't be fired or they can't be physically attacked by the contractor if they're whistleblowers? Another question is whether or not the government has to prove that there was knowing fraud. It can be very difficult for the government to prove knowing fraud on the part of the contractor. Is it enough for civil remedies, for example, for the government to be able to show that the contractor acted recklessly? Acting recklessly is arguably definable as proceeding in the face of a known risk. Is recklessness enough to warrant a fraud penalty? Then how large should those penalties be? Should they be something in the nature of contractual remedies, really just making the government whole, or should they be really severe penalties like we see in bribery? Remember, the reason that we see such severe criminal penalties, such long criminal sentences in criminal bribery, is because more often than not, briberies aren't detected. They're by definition secret. Well, in fraud, should there be equally severe penalties, perhaps monetary penalties imposed against contractors, because it's difficult to discern and recover on fraud. So the question is whether or not how severe the penalty should be. Again, coming full circle, is this really a contractual question? Should this be resolved within the four corners of a contract through normal contractual processes, or should it be dealt with separately, under, for example, in the United States, under the False Claims Act, under a different civil and criminal statute, because of the potential ramifications for the procurement system overall? Another very common anti-corruption strategy is to have a bid protest system, or a bid challenge system as is known, or a remedy system as is known in many nations. They have different names, but these are all fundamentally the same thing. A bid challenge system is an opportunity for a contractor, either before award if the vendor is trying to challenge the terms of the solicitation as being unfair, or after award, claiming that the award wasn't in accordance with the terms of the solicitation. The bid protest or the bid challenge system is an opportunity for the vendor who feels that he's wronged to get a hearing either before an agency, the contracting agency itself, an independent agency. So, for example, the Government Accountability Office in the U.S. government is an independent agency that hears bid challenges, or to bring it before a court. And so, for example, the UN model law on procurement, the UN Commission on International Trade law, or the UNCITRAL model law. The UNCITRAL model law, as many systems do around the world, recognizes that a bid challenge can be brought in either of these three fora. The goal or the problem is trying to figure out what exactly the bid challenge system is supposed to do. Is a bid challenge system intended to right the wrong done to the protesting challenger, to the protesting vendor, the losing bidder? So is it a question of righting the wrong done that bidder? Or alternatively, is the bid challenge system really an early warning system, a way for the government to be put on alert of systems failures, of things that are going wrong inside the system? It's worthwhile noting, as we sort out these problems, these questions, it's worthwhile noting that bid challenges or bid protests are actually a really bad way of addressing classic corruption, things like bribery or gratuities, because the officials, typically lawyers who are running the agency system for hearing bid challenges, or the judges in the courts, they typically lack subpoena power. They lack the ability to go out in the field to gather, to investigate. So because they lack that investigative power, they lack ready access oftentimes to the ability, for example, to use force if necessary to protect themselves. They're oftentimes bad at investigating and dealing with classic corruption. So a bid challenge system is a good example of an anti-corruption device that is really not about dealing with classic corruption like bribery by and large, but instead it's about making sure that the process works. There's a faith that the rules that set up the process are going to ensure best value. So the bid challenge system, the bid protest system, is intended to make sure that those procedures, those processes that are established by law, do in fact ensure, guarantee best value in any given procurement. An issue we're going to be turning back to when we discuss compliance in the next unit is the question of ethics and how they fit in a compliance system. So ethics rules in the government typically address issues like gifts or conflicts of interest or revolving door. These are all questions that we raised before, but the ethics rules set particular guidelines for what an agency official can do and stay within the law. An open question is whether or not rules are enough. We'll be talking about this in the context of compliance. Is it necessary to have an overarching system of norms, of ethics, when the rules aren't clear enough? Those overarching systems of norms can help inform what the official will do in a difficult situation. Another question is whether or not there should be another set of ethics rules. There should be an overall set of government ethics rules that govern all the government employees, and there should be another harsher set of rules that are specifically applicable to procuring officials because of the acute risk of corruption in the context of procurement. So, for example, should there be special rules that deal with how procuring officials should deal with confidential bidding information? Should there be special rules and sanctions for officials that misuse or mishandle that information? So you see there, you have a traditional set of government-wide rules dealing with issues, for example, of conflict of interest, and then on top of that, a potentially harsher set of rules, as we have under the Procurement Integrity Act in the United States, a potentially harsher set of rules that apply just to procuring officials. Another anti-corruption system or method in a procurement system is oversight. That can be oversight by the legislature. It can be oversight by, for example, investigators and an inspector general. what's worthwhile emphasizing is that very often the legislature or the investigators assessing what an agency has done in a procurement will use the existing system of rules, so that the system of rules that are designed to ensure that the agency acts and achieves best value, that system of rules becomes a benchmark that can be used in the oversight process. And the oversight process, or the knowing that an oversight process might occur, that itself helps keep the system clean. Big challenges, for example, are arguably a form of oversight as well. Another kind of oversight that we see increasingly commonly around the world is oversight by community involvement in the procurement. And the community involvement can take different forms depending on the stage of the procurement we're involved in, whether or not it's in planning, in the planning stage. Some members of the community are particularly appropriate to be involved in the planning stage. The competition typically requires professionals who have more experience in government procurement. If they come in from the community and provide oversight, they can be very beneficial, very useful, very healthy voices to have in the process to make sure that the process is proceeding in a clean manner. Then post-award is another type of community involvement. Very oftentimes the people who are affected by a particular system that the government has bought or particular services that the government has bought, post-award the community will provide oversight, will provide feedback on how well that service is being delivered or how well a particular good that the government has purchased is performing. Another anti-corruption tool, and one that we're going to be dealing with in much more detail in the next unit, is compliance. And as we're going to be talking about in the next unit, that compliance can either be by the corporation. That's how it's really been done since the 1960s. The corporation will set up its own internal controls, the corporate compliance systems. But we're beginning to see governments that consciously set up compliance systems that parallel those of the contractors. Of course, governments have always had internal rules governing their own behavior, systems for ensuring that those rules are complied with, etc. That's so that the internal governance mechanisms inside a government are in essence a form of compliance. But what we're seeing is that the governments are beginning to track, to parallel exactly what the contractors are doing. And that's an important development we'll be talking about in the next units. What's remarkable about compliance is when we talk about this in the next unit is that the compliance standards are really very, very, very common from nation to nation. So that as a result, if a contractor sets up a compliance system in one country, that contractor can probably use that same compliance system under the same sorts of standards in the next country in which it's doing business. This next anti-corruption strategy, the use of boards to make decisions, rather than leaving individual officials to make decisions, but using a board to act collegially, is an interesting strategy because it's really based on psychological and social factors. It's harder to corrupt an entire board rather than individuals. So that if a nation or a system wants to protect itself to make sure that the procurement decisions are not being corrupted by outsiders, oftentimes that system or the nation will rely on boards to make really important decisions because, again, it's harder to corrupt the entire board. The board, in essence, becomes a buffer against corruption. The final anti-corruption strategy we want to talk about here is the use of audits. And this, by the way, is a picture from the Government Accounting Office from the 1930s. The Government Accounting Office before World War II reviewed all the purchases being made by the federal government, and this was a huge task. It was an after-the-fact audit, and it obviously was very labor-intensive, and it's difficult to sustain in a system because of the huge cost of auditing everything. So audits will typically be done after the fact on a more spot basis. Increasingly, we're seeing electronic audits that agencies are able to use electronic systems for data mining, for example, to identify aberrations in the data, to find, for example, fraud. The challenge, though, is that as we move into an assessment after the fact and an assessment that's really taken out of context, the question is whether or not the auditors are really going to understand what they're seeing. If there is an aberration, and that aberration can be explained by the specific factual context, is there a problem in relying on audits? Because in fact, the agency or the contractor may have acted appropriately. It's just looking at those actions in the abstract, not in context, may be misleading for the auditors. Another question that needs to be resolved is whether or not the auditors are just looking for aberrations. Are they looking for mistakes and compiling those mistakes? Or more broadly, are they trying to see a pattern of mistakes, a pattern of problems in order to proffer management solutions? So another tension in the auditing function. Is it really about finding mistakes, or is it more broadly about deriving management solutions? Thanks for joining us for this discussion of the various strategies that are used around the world in many, many systems around the world in many nations used for combating corruption in procurement in an effort to get best value for the men, the women, and the children who are served by those procurement systems by stopping corruption that both undermines performance in those systems and, very significantly, undermines faith in the government sponsoring those procurement systems.